What is element of contract, or what is the definition of element of contract? Element of contract is a basic requirement for agreement to be legally enforceable. In some states or country, some element can be satisfied by a valid substitute, meaning before a contract can be a legal contract, they need to have all these elements in the contract itself. There are about 6 elements of contract, which is offer, acceptance, certainty of terms, consideration, intention to create legal relation, and capacities of parties.
The definition of intention to create legal relation is intention of parties to the contract to be legally bound with legal consequences to sue or to be sued in case of failure to perform. Next, the English common law based on two presumptions to determine the existence of intention. For commercial or business agreement, when two parties enter into a commercial contract or agreement, English law presumes that the parties have intention to create legal relation. Thus, there will be a binding contract between the parties. If one party breaches the contract, another party has a right to sue. However, the above presumption may be rebutted by using a clause. Subject to contract or subject to approval of a formal contract. The effect of this clause will not bind the parties to perform the contract until a formal contract is exacted. For family or domestic agreement, it refers to an agreement made between family members, whereas social agreement refers to an agreement between friends, work colleagues, and those sharing household. The English law presumes that there is no intention to create legal relation. Thus, there will be no binding contract between the parties. If one of the parties breaches the contract, another party will not have a right to sue.
Situation. Mr. Haziq and Mrs. Noor are happily married. With their newborn, they both agree to buy a new car. Mrs. Noor caught her husband cheating on her, and Mr. Haziq asked for divorce. They both agree and sign a contract that Mr. Noor will have the right ownership towards the car if she settles the payment. After Mrs. Noor have settled a debt, Mr. Haziq refused to hand over the car ownership to her. Mrs. Noor is furious and decides to bring this matter to the court. Referring to the current case, Mr. Haziq and Mrs. Noor have signed an agreement where Mrs. Noor can get full ownership of the car if she settles the full payment. Hence, there is an intention to create legal relation and there's a binding contract between them. So, the conclusion for this case is Mr. Haziq had breached the contract, thus Mr. Noor has the right to sue him.
Capacity. Capacity is one of the elements of contract. Capacity can be defined as a party that has legal ability to enter into a contract. It involves mental capacity, which is the ability to understand the contents of the documents. Capacity also means a person has to be competent as defined by law. Someone's capacity is determined by whether or not they have reached the age of majority and if they are mentally capable of understanding the applicable contract terms.
Secondly, the factor of capacity is a soundness of mind. The soundness of mind is the capability of the person to understand and to form a rational judgment as to the effect of the contract upon the interest at the time he made a contract. There are two situations allowing a person to make a contract or not. Firstly, if the person is usually of unsound mind, but occasionally of a sound mind, he can make any contract when he is a sound mind. Secondly, if a person is usually of a sound mind, but occasionally of the unsound mind, he cannot make any contract when he is an unsound mind. Lastly, a contract by an unsound-minded person can be rescinded if, firstly, at the time the contract interact, he was capable to understand his action. Secondly, the other party knows about it.
There are two factors of capacity, which is age factor and soundness of mind. The first one is age factor. Age maturity law is 18 years and older. Sometimes minor also can enter into the contract if the contract is for housing, food, or things that necessary to sustain life. Under common law, all contracts entered into by minor are voidable at the option of the minor, which is either before or after becoming an adult. It can be differs according to types of contract. The first one, minor obtain interest of a permanent continuing nature, which is it is binding until disclaimed by minor. The second one is contracts not continuous in operation, which is it is not binding unless ratified by minor within reasonable time after reaching the age of majority.
Psychological statistics is disguised the highest degree to which a person could be convinced that something is true. Epistemic statistics is an epistemic property of belief which a person has a rational grounds for the belief. There are two types of statistics, namely epistemic statistics and psychology statistics.
Certainty. Section 30 of the Contract Act 1950. Every term of an agreement must be certain or capable of being ascertained. If not, the contract may be void. The fact is there was an agreement in writing for the wood during 1930, together with an option. There was a certainty applied in this case, because always hot sellers BHD agreed to sell and given a guarantee that the oven would have a temperature of not lower than 1500 C.
Lastly, is conclusion. Intention to create legal relations is often overlooked, but this case highlights how this principle can sometimes be critical to the enforceability of a contract. Although the concept of an informal agreement based maybe on a handshake or a gentleman's agreement could attract individuals and small business in particular, such an informal agreement may be hazardous. If the agreement was established in an atmosphere that would not lend itself to normal business negotiation, it is especially so. For parties that intend to form a binding legal contract, it is important that they carefully write out the terms so that there can be no disputes as the parties intend. Thank you.